So the Supreme Court has just dropped a 623 emergency ruling that has completely shaken the nation and is already sending shock waves across the entire political and legal system. This isn't just another case. This one has massive nationwide implications, and depending on how it's interpreted and applied, it could fundamentally change the balance of power between the states and the federal government. We need to break down what exactly the court ruled, what it means, and why legal experts on both sides are calling this one of the most consequential emergency decisions in recent years. Now, real quick, before we jump in, I want to ask you all for a quick favor. Looking at the analytics, about 60% of viewers who regularly watch these videos aren't actually subscribed. If you find value in these breakdowns and you want this kind of important legal news to reach more people, please take a second to hit that subscribe button. It's free. It helps tremendously with the algorithm, and it ensures you never miss when the Supreme Court makes another major move like this one. All right, now let's get into the story. So, here's what just happened. The Supreme Court, in a 6-3 decision, issued an emergency order late last night that is already creating tension between multiple states and the federal government, specifically the Department of Justice. This ruling involves a major federal enforcement issue that could reshape how far Washington can go when it comes to enforcing or blocking state-level laws. And once again, just like we saw in the Texas border dispute, the core of this fight centers on the limits of federal power versus state sovereignty. This time, however, the case reached the Supreme Court faster than anyone expected. The court's 6-3 emergency decision effectively sided with the states, saying that the federal government may have overstepped its authority in seeking broad nationwide injunctions that prevent states from enforcing their own laws. That might sound technical, but trust me, it's a big deal, because what the Supreme Court just signaled is that the federal government can't simply use the courts to shut down a state law nationwide before it even fully takes effect. Let's unpack what led to this and what the 6-3 ruling actually said. A few weeks what led to this emergency decision ago, multiple states filed lawsuits challenging what they argued was federal overreach. They said that certain actions by federal agencies, especially under emergency orders, were bypassing both Congress and the courts and were effectively rewriting state laws without legislative approval. The lower courts responded by granting nationwide injunctions, blocking those state laws entirely. But that's exactly the kind of judicial action the Supreme Court has now taken aim at. In this 6-3 emergency decision, the court emphasized that lower courts do not have the authority to issue sweeping nationwide blocks when the issue only affects specific plaintiffs. In simple terms, the Supreme Court is saying enough with the universal injunctions. Federal judges can't just hit pause on entire state laws that apply to millions of people if the dispute involves just a handful of plaintiffs. This echoes what the court said earlier this year in Labrador versus Poe, which placed similar limits on lower courts' power. But this latest order goes even further, applying those principles in real time and signaling a clear warning to lower courts that the era of nationwide injunctions may be coming to an end. Now, as soon as the ruling came down, the response was immediate and intense. State officials are calling it a major victory for federalism and state self-governance. Meanwhile, officials inside the DOJ are privately describing it as a legal earthquake. That's because this ruling could directly affect dozens of ongoing cases, from immigration enforcement and gun regulations to election oversight and even environmental rules. Let's look at one specific example. Under the new interpretation, if a state passes a controversial law, say on border control or firearm policy, a single federal judge can no longer freeze that law across the entire country. Instead, relief would be limited only to the specific parties involved in that lawsuit. That's a huge shift. It means states now have more breathing room to enforce their laws, even when those laws are being challenged in court. And the fact that the Supreme Court issued this as an emergency ruling, not a full opinion after oral arguments, shows just how urgent the justices viewed the matter. Now, here's where it gets even more interesting. Justice Gorsuch, in a concurring opinion, emphasized that injunctions like these should only go as far as necessary to protect the plaintiffs, not to rewrite the rules for the entire country. He wrote that courts must return to the traditional limits of equitable relief and stop acting like many legislatures. That line, many legislatores, is striking. It's a direct rebuke to the pattern of lower courts, the constitutional fallout issuing broad national rulings that effectively function like policy decisions rather than judicial ones. Meanwhile, Justice Sotomayor and the two other dissenting justices warned that restricting nationwide injunctions could create confusion and unequal enforcement, since some states might enforce a law while others cannot, but the majority clearly wasn't persuaded. The court's message is clear: judges are not policymakers, and that principle applied across the board could reshape federal litigation strategy for years to come. Now, here's the political fallout. Almost immediately after the ruling, the White House and the Department of Justice released carefully worded statements saying they were reviewing the court's order translation. They know this changes the playing field. And just like we saw in the Texas border case, states are wasting no time invoking this new Supreme Court precedent to strengthen their legal positions. For example, attorneys general from several states have already filed supplemental briefs citing this ruling as direct support for their claims against federal overreach. In one of those filings, state lawyers explicitly argued that the Supreme Court has reaffirmed that states retain the right to defend their sovereignty without being subjected to blanket injunctions from unelected judges. That line sums up what's really at stake here: power. Who gets to decide what's enforced, where, and by whom? The states or Washington, D.C.? Now, legally speaking, the implications are staggering. This ruling will likely restrict federal agencies from using the courts as a tool to block state laws in their entirety. Instead, agencies will need to pursue narrower relief, meaning that policy disputes will need to be resolved politically, not judicially. In other words, the Supreme Court just told the lower courts, stay in your lane. And here's why that matters. For years, both parties, Democrats and Republicans, have used federal courts to push nationwide outcomes when they couldn't get their way through legislation. This ruling effectively cuts off that shortcut. So, regardless of your political stance, this changes how the game is played. If you want sweeping change, you'll now have to win it through Congress or through elections, not through a single federal judge's order. Now, a lot of you are asking, what happens next? Here's what we know. Because this was an emergency order, it doesn't close the door on future litigation. It simply sets a precedent that lower courts will have to follow moving forward. The case will likely go back to the appellate level, where judges will need to apply this new, narrower framework. And make no mistake, this issue is far from over. The federal government will likely challenge this interpretation in other cases, hoping to carve out exceptions where they argue the national interest requires broader relief. But the Supreme Court's message was crystal clear. The Constitution doesn't allow judges to govern an entire nation from their courtroom. Now, stepping back for a moment, what makes this decision so significant is the context. The court has been steadily building toward this for years, pushing back against judicial activism and reasserting the separation of powers. This 6-3 emergency ruling is just the latest and strongest signal yet that the court wants to restore constitutional boundaries. And in practical terms, it could affect everything from gun rights and immigration enforcement to pandemic policies and election oversight. So when we say this decision shook America, it's not an exaggeration. It really did, because the ripple effects of this ruling will be felt across nearly every major policy debate in the coming years. Now, I'll leave you with this. Regardless of where you stand, national reactions and political shockwaves politically, this moment represents a turning point in the relationship between the states, the courts, and the federal government. The Supreme Court's 6-3 emergency ruling is a reminder that our constitutional system is built on balance, and when that balance tips too far in one direction, the court will step in to correct it. So the big question now is, how far will this correction go? Will future courts follow this new standard, or will they try to test its limits? Either way, this is one of those decisions that law schools and policymakers will be studying for decades. If you found this breakdown helpful and you want to stay updated on these developments, make sure you like, comment, and subscribe. It helps a ton with the algorithm and ensures that this kind of important legal news keeps reaching more people who want to stay informed.